attorneys for his defense team. Joining me now is Elliot Felig, attorney at Elliot Felig and Associates. Elliot, nice to have you back on the show with us.
Thank you.
Elliot, attorneys Joe DeGenova and Victoria Townsend, they cannot join the president's legal team due to conflict of interests there. Now, Bob Mueller has 13 federal prosecutors, very experienced prosecutors, 30 FBI agents. The president has one full-time and one part-time lawyer. Is he already on the back foot here?
I think the president will step up more. And Jay Sekulow, though, has been taking the lead on this, and he does seem to be doing more than maybe 10 lawyers would be doing. But we live in a country with no shortage of lawyers, no shortage of former prosecutors, no shortage of former U.S. attorneys who are eager to take a nice-sized retainer. I think in the end the president is going to be fully staffed with his legal team. Well,
one of the reasons that he lost one of his lawyers is because he said he may want to testify, to speak to Robert Mueller. Do you think he's going to do that?
I think ultimately the president is not going to have a choice. Mueller wants to speak to the president, and the president, prosecutors have a lot of tools at their arsenal. Ultimately, when prosecutors want someone to be questioned, they find a way to do it unless the person is, unless you can't locate the person, they're on some corner of the globe where we can't find them. They have a lot of tools at their disposal. The president has said over and over again, I'm willing to testify. He said, I'm willing to do it under oath. So they'll get it done. They'll negotiate the parameters, the extent of the questioning, where it will occur, how long it will be, whether it will be in writing or verbal, whether it will be under oath. I suspect the president is going to be questioned.
There is a lot of concern about that because the president tends to get himself into trouble sometimes when he speaks freely.
Right.
Should his lawyers not advise him to assert executive privilege?
Well, look, I'd have even more gray hair than I do already if I had a client like Donald Trump, who appears to be impossible to control. That being said, executive privilege is actually extremely limited as a doctrine. It exists not by statute, but by a series of court decisions. So it's up to the courts to determine how broad executive privilege is, and generally they've viewed it somewhat narrowly. If he can assert that there's a major risk to national security, or if he could say, I can't carry out my duties as president if I'm questioned about this, then maybe he'd have a shot at succeeding with by asserting executive privilege. I don't think, though, shielding himself or those close to him from liability, which would be the real motivation here, I don't think the courts would accept that as a valid assertion of executive privilege.
Elliot, you heard Ken Starr saying he doesn't think that there'll be collusion. We've heard from the House committees investigating, saying that there's no collusion. And now we're hearing that it seems like Robert Mueller is wrapping up. Do you get the sense that he's starting to wrap this up now?
I do. As a prosecutor, you always start with the little fish, and you start to gather information, and then you build up to the bigger fish. There's no bigger fish than the sitting president of the United States. So it suggests to me that they're close to an agreement about the president, or that they're seeking an agreement about the president testifying, that they are close to wrapping up at least the investigative phase. You still have Manafort facing a trial. That would happen months down the road.
And you also have potential obstruction of justice. And much is being made of the Comey memos and the McCabe memos. Now, these are subjective accounts from people who have an interest in how this plays out. How much legal weight do these memos have?
Well, James Comey is a witness, but he's a witness like anyone else. And there's no denying presidents, as a general matter, any president can fire an FBI director with or without cause. So an obstruction case, I think, would require more than simply Comey being fired or Comey making factual assertions in relation to his firing.
But when you look at the way these memos are seen by a court, do they have more weight than, for example, me writing a memo because it's from an official?
No, in the end, a memo by a person who is a witness is a corroboration simply of themselves. Right. It might not even be admitted in court because it is a form of hearsay, even though it's by the person himself. It's not, it doesn't have the weight of an additional eyewitness or of a piece of documentary evidence, a video, an audio tape, something like that.
All right. Appreciate your analysis as always. Elliot Felig, good to have you with us. Still ahead, up, and